everyone. Welcome to Crime in Court. My name is Heather, and this is the Commonwealth versus Karen Reed Trial 2.0. And we are on episode 124 Motions in Limine Blood Extrapolation. So, we're going to go over, as the title kind of demonstrates, we're going to go over motions in limine today. So, there were, as I've stated in previous videos, we've had many motions in limine dropping on the docket for the Karen Reed case in the last like 24 hours. So I am going through them. I'm breaking them down topic by topic. And we are going to get started. This is the blood extrapolation. And please hit that like button as we get started. All right, so up first is the Commonwealth's motion in limine to admit results of the defendant's blood draw at Good Samaritan Hospital and resulting serum conversion and retrograde extrapolation. So obviously the Commonwealth, okay, so backtrack. If you're not familiar, Karen Reed, after 911 was called, John was taken from the scene, taken to the hospital. After all of that happened and people left the scene that morning, Karen Reed and was being driven by Carrie Roberts. Carrie Roberts got a call to come back to the scene, and at that point, they sectioned Karen Reed, which means they thought that she was expressing that she might do harm to herself, so they sectioned her for her protection, is what they're saying. I don't know who called on this or what. The rumor is she said something about taking her own life to Bill Reed, and then but I don't find that she would do that. And then Bill Reed called the police, and then the police called and then had Roberts take her back. I don't know. I don't know exactly how it all transpired because I don't think it ever came out in testimony exactly clearly. But anyways, so she was sectioned at the hospital. They drew some blood. It was not done properly for a criminal act. It was done in relation to the hospital's policies, but not in protocol for using it for a crime, using it for evidence. So here we have the Commonwealth is trying to use this blood draw as evidence that she was too drunk and she did this when she was drinking. So now comes the Commonwealth and respectively moves moves Honorable Court in limine to admit evidence about the defendant's blood draw at Good Samaritan during the course of her medical treatment and the results from a blood alcohol serum conversion and retrograde extrapolation to establish the percentage of alcohol in the defendant's blood. A certificate signed and sworn to by a chemist of the Department of the State Police or by a chemist of a laboratory certified by the Department of Public Health, which contains the results of an analysis made by such chemist of the percentage of alcohol in such blood shall be prima facie evidence of the percentage of alcohol in such blood. Yes, but there has to be a certain protocol in taking that blood. There has to be protocol in how it's tested. It has to be there's certain standards that need to be met before you can even get to, well, there's blood alcohol in this person's blood. And they didn't do that. And one of the guys admitted on the stand, this is a total guess, if she took her last drink at midnight. We don't know. So we can't tell you for sure. So there's that. And they didn't have they lied about the number of drinks that she took or the number of drinks that she had at the bars. Yuri Buchanan was on the stand and they were rolling surveillance footage of the bar and he's like, "Oh, there she just took another drink." And I'm like, "Where?" Like I didn't see her order another drink there. So either Yuri has crazy good eyes that that can perceive things that are so fast most normal people can't see it, or he's lying. So the defendant's medical record of the blood test is admissible under general law, chapter 233, section 7 something. Pursuant to the statute, records kept by hospitals shall be admissible and may be admitted by the court in its discretion as evidence in the courts of the Commonwealth so far as such records relate to the treatment and medical history of such cases, and the court may, in its discretion, admit copies of such records if certified by the persons in custody thereof to be true and complete. Medical records generated for evaluation and treatment purposes do not constitute testimonial evidence. Okay. Commonwealth anticipates that the medical providers who participated in the blood draw will testify to their knowledge, training, and expertise in how the test was administered to demonstrate their reliable basis in the knowledge and experience in this discipline. Additionally, witnesses will testify about blood alcohol serum conversion and retrograde extrapolation to establish the percentage of alcohol in the defendant's blood at the time that she was driving her SUV and struck John O'Keefe. Blood alcohol serum conversion and retrograde extrapolation is admissible. Yeah, it may be, but you need a chain of command first before you do that, and you need protocols in place before you do that. And none of that was done here. So this is the defendant's motion in limine to exclude the serum, plasma, ethanol concentration, blood ethanol concentration conversion, and corresponding retrograde extrapolation analysis. Now comes the defendant, Karen Reed, and respectfully moves this honorable court in limine to exclude evidence of serum, plasma, ethanol concentration tests performed by Good Samaritan Hospital at 9:08 a.m. on January 28, 2022. So they took her blood at 9:08 a.m. John was found at 6:00 or I think it was like 6:03, 6:04 in the morning. And Karen dropped him off at sometime after midnight. So we're talking hours later. By extension, Ms. Reed necessarily moves to exclude the blood ethanol concentration conversion performed by the Massachusetts State Police as well as the corresponding retrograde extrapolation analysis. As grounds for this motion, Ms. Reed states that as acknowledged by MSP forensic scientist Nicholas C. Roberts in his report, the ethanol result used in the reports was provided by an external party. The testing to obtain the ethanol result was not performed by the Massachusetts State Police Crime Laboratory, and therefore the reports do not fall under the laboratory scope of accreditation. So the lab work was done with the hospital, not the MSP. So they can't use it, is what she's saying. That's a brilliant argument. I love it. It's not going to work with Judge Cannoni at the helm of this whole case, but it's a great argument, and it should work. But will it? I don't know. Pardon if you heard we have neighbors with very loud cars. It just went by. All right, so since the Commonwealth cannot establish that the blood test result administered by Good Samaritan Medical Center is reliable for the purposes of criminal prosecution, and that's what they were arguing before, and hopefully they have tightened up their argument here. Since it's not reliable for the purposes of criminal prosecution, the serum/plasma ethanol concentration result and the corresponding blood ethanol conversion and retrograde extrapolation, which derived their results from the initial results, should be excluded as unreliable and not the product of the principle and methods. So basically, the hospital took her blood based on hospital protocol, which was fine for hospital protocol, not for criminal prosecution. So if they wanted that, the police needed to come in and get her blood a different way. They needed to take it on their own. They needed to use their own protocol. So instead, the Good Samaritan Hospital or Medical Center, they took her blood, they did the testing, they came up with a result. That result then was shared with people at MSP. Those people and the Commonwealth's experts all said, well, okay, she had this as her range of alcohol, which was like incredibly high, and it was a very wide range, which made no sense to me. So it was just, to me, that makes it a total guess because it was a huge range of what her alcohol percentage could be, according to the Commonwealth's experts who got this uh, test result that was done in a hospital protocol manner and not a criminal prosecutorial type of manner where you would do it in a different way. I know Nurse Kim talks about this on her channel a lot because she's a nurse and she knows that if you are taking blood for criminal protocol, there's different protocol than if you're just taking it for blood draw. So she's gone over that in uh, to an extent on her channel. She's gone over it. All right, so factual background. On January 29th, around 7:26 a.m., Ms. Reed was admitted to Good Samaritan Medical Center as a result of the acute grief reaction that she experienced after learning that her then boyfriend, Officer John O'Keefe, had passed away. In addition to, so she was in a grief-stricken, panic, shock type of um, emotional state. In addition to evaluating her, the hospital performed blood work and a urine drug test, which included tests for the presence of drugs and alcohol. Ms. Reed tested negative for any drugs for which the hospital screened. The hospital, however, recorded an alcohol level in Ms. Reed's blood of 93 milligrams, whatever that MGDL stands for. Using the value from the test conducted by the hospital and without ever having applied for a warrant, they never had a warrant, I forgot about that, to themselves test, wait, what? Using the value, let me start that over. Using the value from the test conducted by the hospital and without ever having applied for a warrant to themselves test Ms. Reed's blood, as would be normal course in a prosecution involving any aggravated form of operating under the influence. Massachusetts State Police performed a conversion on the reported 93 MGL or MGDL result to a blood ethanol concentration ranging from 0.078 to 0.083%. Based on based on three different conversion factors on May 4th, 2022. So using that conversion, Mr. Roberts then conducted a retrograde extrapolation on June 6th, 2022. In both reports, Mr. Roberts explicitly notes that the serum/plasma ethanol concentration obtained from Good Samaritan was not performed by the Massachusetts State Police Crime Laboratory, and therefore this report does not fall under the laboratory scope of accreditation. How many times did he state that? Both reports. Both reports, he says that. So there you have it. I mean, they took her blood. They didn't take a warrant. They didn't get a warrant for her blood draw on their own. They just used the hospital's technology and whatnot, but it's not accredited. Their lab's not accredited for crime lab type work in prosecuting people. So it's their protocol is different. It's not the same, and they just can't use it. Is what I'm getting from this. So after the first trial on September 17th, 2024, the toxicology unit. So after the first trial, the toxicology unit administrative manual updated conversion factors used by the Massachusetts State Police Crime Lab to align with the ANSI/ASB Best Practice Recommendation 122, First Edition 2024 document. Per a new report dated October 10th, 2024, authored by forensic scientist Hannah Knowles, the new serum/plasma ethanol concentration estimated by the Massachusetts State Police Crime Lab is now between 0.78 and 0.82%. So it went down by 1 here. However, in Knoll's report, she uses a time interval of 8.5 hours with an additional 2-hour allowance from the time of 12:45, the time of the alleged incident, in an attempt to account for the uncertainties associated with the drinking history of the subject prior to the time interval. Her calculations determined that Ms. Reed's blood alcohol content could have been between 0.14 grams and 0.28 grams at 0:45 minutes or hours. That would be at 12:45 in the 12:45 at p.m. What I'm trying to say. On January 29th, 2022, this range differs from the range testified to by the forensic scientist used by the Commonwealth in the first trial, Nicholas Roberts, who indicated that the range would have been 0.13 to 0.29. So they're changing it now to say 0.14 to 0.28. It used to be 13 to 29, now it's 14 to 28. Okay. So this calculation assumes that the subject's BAC had peaked at or prior to the start of the time interval, indicating that the subject had consumed no ethanol a half hour to an hour and a half prior to the time interval. So are they saying she didn't drink? I don't know. Are they saying that that means she hadn't had anything to drink between an hour and a half before 12:45 at night? I think that's what they're trying to say there. All right, argument both because both the initial serum slash plasma conversion report and the subsequent retrograde extrapolation analysis are based on a blood test about which the parties lack essential information, including testing procedures and type of testing, the blood test results should be excluded. Retrograde extrapolation is a mathematical calculation used to establish a person's blood alcohol level at a particular point in time by working backward from the time the blood alcohol was taken, or the blood alcohol test was taken, taking into consideration rates of both absorption and excretion. So you sweat it out, you absorb it, you urinate, and you lose some of that blood alcohol. So they're not even taking those things into consideration here. The SJC has held that generally speaking, retrograde extrapolation analysis meets the Daubert-Lanigan standards for admissibility. Breathalyzer test results are generally admissible without the need for the retrograde extrapolation without the need for expert testimony when taken within a reasonable time defined by the SJC as 3 hours after operation of a vehicle. In this case, Col- Coltori, in Coltori, they lay out a narrow exception in which expert testimony is required where the Commonwealth is proceeding under an impaired ability theory, as opposed to a per se theory, and the test is administered outside of the 3-hour window, necessitating retrograde extrapolation. Expert testimony is required. So they need an expert to verify this. All right, so just last year, the Supreme Judicial Court addressed the issue of a defendant's consent to a blood test in a prosecution for simple and aggravated forms of OUI in comparison cases, Commonwealth versus Cappellucci and Commonwealth versus Zucchino. You guys have a lot of Italian names over there. The court held that the consent requirement of MGL 90 section 24 only applies in prosecutions for simple OUI and for under this particular statute rather than to any of the aggravated forms of OUI. Accordingly, whether Ms. Reed consented to the alcohol blood test or not is not at issue here. What is at issue, however, is that the parties lack essential information about how Good Samaritan Medical Center drew and tested Ms. Reed's blood. It is standard practice in prosecutions for OUI and its aggravated forms for police to request and be granted a warrant so that they can themselves test a defendant's blood through a certified analyst. In let me repeat that. So, again, Good Samaritan Medical Center did the blood draw and they did the testing in the lab at their own lab. What they're saying here, though, is it is standard practice in prosecutions for OUI and its aggravated forms, so this too, for police to request and be granted a warrant, which they never did, so that they can themselves bring on their own certified analyst who can do the blood draw themselves. And that would be in accordance with the provisions of whatever that is. So, the protocol, the rules, the statutes that they're supposed to follow, they should have done that. So, while these requirements pertain only to analysts working for the state police and not to hospital personnel, they are in place to ensure that blood testing for ethanol undergoes a standardized, reliable, repeatable procedure. The admissibility of any given test result will be governed by the adherence to the policies and procedures, and while strict adherence may not be required, any variance will certainly affect the weight given the evidence by the fact finder. Regulations for the analysis of blood are contained in this statute here. So it becomes less reliable if it was not done based on policies and procedures for the Massachusetts State Police. The MSP utilized gas chromatography testing rather than enzymatic immunoassay testing, which presumably was used by the hospital here. So we've got two footnotes. One says ANSI, National Accreditation Board, Certificate of Accreditation for the Massachusetts State Police Forensic Services Division Crime Laboratories, and there's a PDF there. So she's citing their policies or the author of this filing, I should say. I don't want to assume that it's Liza Little, but she probably does a lot of the filings here. The next footnote says case of acute hepatic injury and elevated ethanol levels in a non-alcoholic adult. I don't know. That's some case that they're referring to there. All right, so in the medical records provided under the chemistry section, there is an annotation regarding the drug testing which states this report is intended for use in clinical monitoring and management of patients. It is not intended for use in employment-related drug testing or court-related proceedings. So in its own policies and procedures, they say that it is not, this type of testing is not intended for employment-related drug testing or court-related proceedings. Samples are not routinely tested for adulteration and are assumed to be within the normal physiological pH range of 5 to 8, whatever that is. It looks like inches to me. We'll say 5 to 8 inches of pH range, but I know that's not right because it's quotes there. All right, so the alcohol result is beneath this annotation. It is not clear whether this annotation applies only to the urine drug test or to the alcohol result as well. So there's this quote here, but in all fairness, they're saying it's not clear if it relies to all testing or just the urine testing. Regardless, the defense should not have to guess. The Commonwealth should have, at minimum, provided documentation from the hospital regarding how the alcohol test result was obtained, through what procedure, by whom, and what manner of testing was used, i.e., gas chromatography or enzymatic testing, the latter of which would yield a higher result. So if you're doing a different kind of testing here, then you get a higher yield, a higher result from your test results. So, absent this information, the Commonwealth is unable to establish the reliability of this initial result on its face, in light of the fact that the MSP, Ms. Roberts, and Ms. Knowles each separately acknowledged in their respective reports that the serum slash plasma ethanol concentration test does not meet the accreditation standards for reliability outlined in 501 CMR 2.0. We know with certainty that the serum slash plasma ethanol concentration test was, at the very least, conducted according to an entirely different scientific protocol. It's apples to oranges. The defense does not take issue with the generally accepted scientific practice of retrograde extrapolation itself, but rather with the data upon which it was based. So you're using bad data in the first place because it wasn't taken, the testing, the blood draw itself, and the testing of the blood was not done in an accredited lab for processing crime scene investigatory evidence. Without reliable foundational information about the initial serum slash plasma result, the plasma conversion to blood ethanol concentration and the retrograde extrapolation from the converted number is not reliable. More precisely, the Commonwealth has not provided any information about the initial result from the hospital that would indicate that the subsequent analyses by Mr. Roberts and or Ms. Knowles are accurate. So nothing to claim or confirm any accuracy of their testing. Instead, three parties involved in this BAC test have expressly disclaimed the legal veracity of these results. GL 90, Chapter 24 states that a certificate signed and sworn to by a chemist of the Department of the State Police or by a chemist of a laboratory certified by the Department of Public Health, which contains the results of an analysis made by such chemist of the percentage of alcohol in such blood, shall be prima facie evidence of the percentage of alcohol in such blood. The analysis of Ms. Reed's blood was not, in fact, at least not completely, by the chemist who signed and sworn the certificate, as is admitted to in the report. So it wasn't the people who said that they tested it were actually not the people who tested it under the certificate. So that's interesting. In his testimony at trial, Mr. Roberts admitted that while the standard lab testing procedure is to conduct two separate tests within the laboratory, with Ms. Reed's sample, he conducted no testing himself. No testing himself, and merely assumed that the hospital's test was accurate. Wow. Both of their analyses were conducted with data that they did not themselves collect. Mr. Roberts himself confirmed that an unreliable base for calculations like we have here is a serious problem for the reliability of the extrapolation result. You do have to base the extrapolation calculation on good. Your starting blocks have to be good. So you have to know the times in which the blood was drawn, the time of the incident, and essentially what your value was for your BAC. All three of Mr. Roberts' key factors are not clearly known. Moreover, the prior retrograde extrapolation was not in keeping with the ANSI/ASB best practices, and thus the new forensic scientist, Hannah Knowles, has now issued a report with a new and different range of BAC, further underscoring the unreliability of the extrapolation in this case. Accordingly, the serum plasma conversion and retrograde extrapolation results should be excluded. Addressing the issue of pure evidentiary admissibility tells us that records kept by hospitals shall be admissible and may be admitted to the court in its discretion as evidence in the courts of the Commonwealth so far as such records relate to the treatment and medical history of such cases. This is not for that. So similarly, Commonwealth, this wasn't for treatment or medical history. This isn't about her treatment. This isn't about her medical history. So it's really not relevant. Similarly, Commonwealth versus Dyer expands that medical records generated for evaluation and treatment purposes do not constitute testimonial evidence and may be admitted into evidence. Both the statute on point and seminal case on medical record admissibility pose conjunctive requirements, treatment and medical history, and evaluation and treatment. The common factor between the two authorities is treatment. Ms. Reed's visit to Good Samaritan Medical Center on January 29, 2022, and the records produced, therefore, were explicitly not part of any process of the administered medical treatment. So there's another way that this is not inadmissible because it's not about her treatment at all. So in Commonwealth versus Malone, it was decided the same year as Dyer found that when the defendant's blood tested was not connected to medical treatment, the Commonwealth's failure to meet the statutory requirements means that the documented hospital records themselves cannot be admitted under the statute hearsay exception. So it's not a hearsay exception because it was not conducted to a medical treatment. Therefore, the results should be excluded. Conclusion: for the above reasons, Ms. Reed respectfully requests that the blood test result from Good Samaritan Medical Center, the serum plasma conversion, and retrograde extrapolation evidence be excluded. So there you have it with the blood, the motions in limine for the blood extrapolation. Obviously, the Commonwealth wants to bring it in, but they didn't have a whole lot of case law or things to cite why. And then here we have a much more, this happens a lot, where Hank's motion's one page. It's a one pager. Two, sorry, it's a two pager. And then you've got Karen Reed's defense team who did a thorough 9-page job of putting together a very clear understanding of why this should not come in, the reasons, the problems with the testing, the blood draw itself, the testing results itself, those kinds of things. Like if you start with bad facts and then take those bad facts and do something with those facts to give you more facts, those other facts shouldn't come into. I mean, it's pretty clear to say if the bad facts, the original bad facts, don't qualify or shouldn't come in at this, the big bad facts shouldn't come in. You know what I'm saying? None of it should come in. So that's my take on it. I think it was a good. I thought I was going to say something else. I thought it was really good how Eliza Little really draws problems with the testing, problems with just the reliability of the report itself, saying like we can't the testing from the lab that actually did the testing, the medical facility that did the testing says, well, this can't be used. Specifically, cannot be used for employment, drug screening, or criminal proceedings. So, I mean, it's in their own paperwork, their policies, their reports, and things like that. So, how can it come into trial to try to convict someone? What do you guys think? Let me know in the comments below if Judge Canoni is going to allow the blood extrapolation to come in again. She allowed it the first time. I think this time around they have a stronger argument because I know that they did try to keep it out the last time and Judge Canoni wasn't having their arguments. But this time I think they have a stronger argument going into, using the testimony of their own experts against them from the Commonwealth and how they weren't even sure that they could use, their their calculations because it's only based on what evidence they were given, the facts that they were given. So again, it goes back to the bad facts. And the bad fact is there's no warrant to draw the blood. The hospital drew the blood and did the testing. So you cannot use it for criminal proceedings. Those are the bad facts against Judge Canoni and the Commonwealth. But will she rule in favor of the defendant? Likely not. Let me know in the comments below what you guys think, and I will see you guys in the next one. Take care. Bye now.